that is the single most jurisdictional important point in this case. Jurisdictionally, the whole law of defamation was never intended. I made it in great detail last time. I'm in the jointer. I'm not repeating. Your lordship is being asked to do violence to the concept of an identity. How can a class of 13 crores be an identifiable class? By very definition. We've argued all the names. I've read the evidence to your lordship. I mean, that would be really repetition. But this is directly the heart of the matter. Law says directly, Subramaniam Swami says directly, identifiable class, para 176. Yes. Now, any application of that in any which way, as a matter of fact, your lordship has got smaller classes. This is the first case I'm coming across where the class is defined as 13 crore people.
Question not answered it on this one. It can't take in its embrace.
My learned friend, I read the written submissions last time. My learned friend argued in the sessions court. I read the written submissions. Written submissions specifically make this point. He orally argued it. The judge notes it. The learned judge notes it. There's no answer. There's no answer. If this is correct, then there is a jurisdictional error. So, I defame him by name, he doesn't file. He files saying that by defaming him by name, I'm defaming the entire class of people standing here. That's the whole thing.
In the order, it's not answered.
It is noted in particular in para small Roman 3 at page 67 of the learned sessions court order. In the revision 5. In the revision 5. I did read it last time, and I'll just remind again. Yes. This I told you last time again, but I'll repeat it again. This is an important point because point taken, point noted, but not answered.
Yes.
I'm only on the
last occasion you pointed out.
I am grateful.
67, 68,
No,
69.
I'm grateful. I'm grateful. I raise it. You can reject it. You can say it is wrong because of 1, 2, 3. You've not dealt with it. I can't show negative. Where have you dealt with it? You've not dealt with it. Then, the learned appellate court has suddenly relied entirely on this magic witness, which I told you lordship last time, is this Yaji. And my learned friends say that he was the only virtue he has is he was present. Your lordship noted me last time at great length. I dealt with Yaji. I showed you the pages also. Yes. But just to remind lordship, two very simple things on Yaji. Yaji, your lordship will note, is a person who suddenly appears like a magic wand 2.25 years after the complaint. Point 1. Point 2, he is not in any list of witnesses. Point 3, he starts his deposition, and your lordship saw with me page 44 to 46 of the compilation last time. I'm grateful. I'm grateful. I'm grateful. He starts by saying, I'm a very strong pillar of the BJP. I have been for 40 years with the BJP, 45. I am now the cultural advisor to the Karnataka government. I have worked with the complainant in this position. I have done so many posts. A man, with that background appearing 2.5 years later, suddenly, without being in the list of witnesses, it's very easy to make a frame of conviction on that. Now, this all I showed to your lordships, the written submissions, page 666. Page 666, written submissions. Directly the point, same thing, taken again by my learned friend Mr. Chima, not answered, not dealt with. But the learned court fully relies on Yaji, doesn't deal with any criticism of Yaji. As a matter of fact, everything else comes down to Yaji, boils down to Yaji because
He has said only Yaji. He says electronic today.
The answer given, just see the irony. There is a whole host of witnesses. They are named in the beginning. None of them is found of any relevance. Most of them have not been there, they have not seen. Yaji appears, I said, 2.5 years later, 2.25 years later. He's got a completely contradictory background. He obviously cannot be a sole reliable witness. Of course, he can be a witness if your lordship finds lots and lots of corroborative evidence. But Malas, the main thing was the documentary evidence. The learned judge, I showed this also to your lordship last time, brushed it aside in 2 sentences saying, yes, yes, it is there. We will see it at the end of the trial. We will see it later. So documentary evidence is out. Yaji is in. Credibility, believability, corroborative is 0. The documentary evidence, if it is inadmissible or not valid, had to be dealt with at this stage. Because you are using Yaji to convict me, to deny me non-suspension of conviction, then documentary evidence can't be brushed aside like that. That's the point.
Lord, today also, Mr. Nanavati has only.
And my lordship has heard today, I was told when I was coming in the car here, that Mr. Nanavati's prime witness is the magical Mr. Yaji Mills. Rightly, well, I mean, he cannot find a new witness now. Whatever is there is only this. With all his forensic ability, even he can't find a witness.
I don't want to read.
Malas, therefore, even today your lordship has got only this Yaji. He's a very infirm basis to not give me suspension of sentence. The sessions court, forget the trial court. I will win by trial, I will lose by trial, etc. The sessions court has to deal with it, Malas. Otherwise, what's the point? Then, Malas, kindly see that just a few more things will be done. I have made the point about the 65B certificate.
Yes.
Your lordship has noted it down.
Yes, sir.
It is well considered a technicality, but there are case after case after case, especially after Justice Nariman's judgment of the IT Act, that it's a mandatory provision. It's not that it's just something your lordship thinks it's technical and brushes it aside. Please produce 3 things. 1, maker certificate prepared by the maker of the CD. There is a CD, there is a maker of the CD, and there is a certificate. Where do the 3 match? Please show to the court. And the certificate issued while producing the CD in open court, it is admitted in writing at page 52, 53 of the CC that the CD was in open condition. Open condition, my lord, remember. Well, let me come to a more important point as I wind up, Wallace. The more important point is that your lordship, Wallace, ultimately, I have, Wallace, the duty to, Wallace, request my lords to consider and decide the suspension one way or the other, Wallace, at your lordship's immediate and earliest convenience. Well, I am here seeking a stay. I am gravely and irreversibly prejudiced without a stay. In my humble and respectful submission, Wallace, it brooks no delay. We have now, everybody has argued. Your lordship, Wallace, may kindly take a call this way or that way. Your lordship, Wallace, may appreciate that denial. And of course, my lord is entitled to do one other thing subject to that. My lord is entitled to give an interlocutory decision and then a final, which is not normally done. I'll be very candid, not normally done. But Wallace, some decision which clarifies my status today is vital. According to me, your lordship has heard us both at great length. Your lordship has seen at this level at 389, my lord is not a trial judge or a conviction judge or acquittal judge. Your lordship is a 389 judge at the moment. Your lordship has seen enough. Your lordship should, come to a decision one way or the other. That is, my humble submission, because that justice would be required. Yashwant Sinha's case was, a Supreme Court order. It was in existence at the time of sentence. Now, that is what they are saying. I am asking myself one question, on Yashwant Sinha's case.
671.
Yes, yes. This is fully dealt with at page 671 of my written submission. We will just turn to that for a minute. Because this is again something apart from Yaji. My learned friend relied a lot on Yashwant Sinha. I repeat, my experience is more limited. There are people here with criminal law more experience. I have yet to find a conviction in defamation at all, or if at all, more than 3 to 6 months. To say that maximum punishment is desirable, what is it desirable for? It's a first-time offender. How is maximum punishment desirable? And how many defamation cases has the lordship found where 2 years is imposed? I mean, your lordship, in the sense, appellate court, but it's coming from below. Your lordship doesn't hear the trial. There is no defamation case that I know with the maximum punishment imposed for the first time. And your lordship is told that we have to cite a case to show that this is the most apposite punishment. Yashwant Sinha cannot be an apposite punishment test. Now see, 660, 671. Written submission. Just turn to 670. But there is not a single reason given factually or contextually as to why Yashwant Sinha mandates that your lordship gives a maximum of 2 years, because 1 year, 11 months and 29 days is not enough. Therefore, give 2 years to a first time offender for a bailable, non-cognizable, anti-societal offense. There is no reason given to your lordship. It's just said Yashwant Sinha, Yashwant Sinha. Now kindly see 671. I mean, Singh, it's not Yashwant Sinha. I'm told it's Yashwant Singh. I see.
Yes.
The same man.
Yeah.
It's the same. The political.
I have not asked.
The most disturbing,
In
just
fact,
see
he has
671. I thought there's a mistyping here. It's Singh here. It's actually Sinha. The most disturbing feature of sentencing part is the manner in which the prosecution placed reliance upon the judgment in Yashwant Singh and the uncritical manner in which the court readily signed the dotted lines. It has been pointed out in the memorandum of appeal that the said judgment would not have any bearing or relevance to the question of sentence in the present case. Now, this is the answer. Because the law applicable to the present case does not permit reliance upon observations made in a case of contempt of court. The lordship is doing contempt of court, well as apples and oranges, or well as bananas and oranges. However, the real pain of the appellant lies elsewhere. The questioned speech relating to the institution of the present prosecution was made on 13th of April. The name of the appellant figured in the Supreme Court because of the alleged content much later in the year. This point I made, 6-9 months before and subsequent. The appellant was warned and told to exercise caution in future on 14/11. It baffles comprehension how for a warning on 14/11, the appellant could be expected to be wiser on 13/4. Retrospectively, I said last time. Therefore,
So they have said.
well, it's the what is recorded in the order is that when I'm giving you something more because you already stood warned on the date of giving you the punishment. Yashwant Sinha being present is neither here nor there. It's irrelevant. The jurisdictional error is that the trial court is saying, I'm punishing you, Mr. Accused, because you were earlier warned by the Supreme Court. You stood warned. The dates show that there is no correlation at all. It's much later. Therefore, the answer can't be that on the date when I'm giving you the punishment, Yashwant Sinha has come. It's irrelevant. The 2 and 2 don't add up together. Whereas I would say, at the end of the day, just give me a minute. Just give me.
In keeping with
Don't worry. Don't.
my apology.
Well, this I will move the application for suspension of sentence. Suspension of sentence, here, your lordship. Perhaps here, your lordship need not grant for at least till the rising of the court.
Perhaps we are not now.
Till the rising of the court, your lordship need not suspend the sentence.
Another year conviction in the state.
Well, if these considerations form a part, as I've shown, then it becomes very, very well. I've also shown a whole set of 6 circumstances of vitiating of the trial. This raises a grave doubt and apprehension about the purity and the fairness of the trial. I would beseech my lord, this way or that way, for your lordship to decide the matter and give quietus to this. And any delay of a single day would cause us.
In fact, now, therefore, we have made clear that we have heard total all the parties, and now we are keeping for judgment only.
I know, I'm making one.
Holidays, we are using all these materials, and we are finally deciding.
There is only one request. There is only one request. I mean, I hate to
And
make.
today again, the Honorable Apex Court has raised the very issue in the case of Muhammadullah Azam Khan. And the court has kept this matter in the month of July, where they have raised the very question.
Well, I am the counsel there.
Yes,
They listed today.
Therefore,
4-3
I have
item
read
18.
that Therefore, I am
I
now,
was to submit
No,
that,
no,
but
no.
my lord, it
No,
is
no,
all,
but-
once it is sub judice,
the
it is
court
sub
has
judice
already
either
posed
way.
that very
but-
question. And what is the offense in that Mohammedullah Azam Khan?
Murder.
No
Oh,
murder.
well, not murder, sir.
Not
Grievous
murder.
hurt.
He is
Grievous hurt.
just sitting on the road with his father. Therefore, the
No, but
FIR is registered
Grievous,
against him.
grievous hurt. Grievous hurt.
That
Grievous
is
hurt
in
case.
the second.
10
But in
years.
the first offense, it was registered as,
No, but
he
I-
is
I-
only
I-
aged 15 years at the relevant point of time.
Well, he is given 10 years there and the High Court suspended the conviction. We are respondents in the Supreme Court. The other side complainant has appealed. And that matter was today listed as court 3 item 18. I was to
That is
argue it,
what
but
I have
I have
read.
come here.
Hurriedly, and
What he
therefore I
had
am
in
just,
mind was yesterday's matter before, my lord, where Mr. Sipal argued.
yes,
That was a different matter where, my lord, that's kept in July. That's different than
No,
this.
no, no. Today, well, I don't know what happened when I came here. Today matter is listed before court number 3 is Justice Joseph's court. Where
no,
well,
that
I
is
had-
not the matter yesterday.
Ah,
that
was
is now
yesterday.
just
That is
only-
where the son was
But
sitting
anyway,
with
my
his
lord,
father, my
that
lord.
is all,
But-
they are all
but
pending.
I'm not concerned. I'm on a
Arguments
different
are
point.
going
No, I'm on a different.
Hmm.
No, in that one is the sentence stands suspended. The matter which I
Yes,
am doing.
Kerala High Court
Where the,
did that.
where the High Court of Allahabad has rejected and refused to entertain,
yesterday.
therefore
That is
they are
that-
approached.
That's right, but then I can equally cite. No, no, kindly see.
Hmm.
I can equally, I'm entitled to cite
Yes,
that the Kerala High Court suspended it. After suspension for 1 month, the Malas Lok Sabha did not allow him to enter the. We Malas moved an application to court 3. On the day I moved the application, the Lok Sabha Malas came through Mr. Mehta and said, today we are allowing him to enter. So the disqualification lifted. It was immediately stayed and lifted. Now, Malas, I have a different unpleasant duty to perform. Malas.
Yes.
I don't want to.
Hmm.
Malas, It's my duty as a counsel to Malas, request my lord to consider giving us Malas, an order this side of the vacation because
this
Malas,
is not possible. In fact, when first occasion I have clarified that on 4th I am leaving the country and therefore I am unable to
no,
pass. and-
that is true.
Sir.
Your lordship Malas may only record then my submission.
Y-
because
Your, yes,
I'm
certainly,
only Malas saying that
yes.
Malas, for all the reasons I've argued,
Hmm.
Malas, some Malas, either interim or final order is required because everybody.
We
Malas, is
pass the
going to
final
recess.
order only after.
Yes,
the opening
your
of
lordship may only
vacation.
note my submission, whether
Yes.
this is a
You
contention.
know,
I have.
only there I may just.
Yes.
It's
permit
very
it.
clearly my submission.
Yes,
That your lordship have also called for the recording.
I have already called for. the
No,
record.
therefore,
Yes.
you know, when the matter is being finally heard and being decided, you know, this there is out of place in my respectful submission.
We are
That's
So
all
my
right.
objection may kindly be noted.
My learned friend Abhishek has certainly been noted.
And
Similarly,
that will
my
amount to
submission,
allowing the
Yes,
petition.
my submission
You
that
can
your
be recorded.
lordship may Malas, consider deciding this side is fine, and we are in extreme emergency is my submission.
Yes,
I
yes,
only make it,
certainly,
that's right.
we record. That till the next council meeting,
Without
Dr.
prejudice to all
Singh.
this, of course, we will file a written submission Malas, within 3-4 days in any case. That
But
we have.
now from 5th onwards, there is a holiday. Summer vacation is commencing from 5th. And
We
this
can file
court is,
it, no, can we file it by 4th?
but then I am unable to pass any order before that.
That's only for assistance, my lord. That's
You,
only
you can file.
for- that's
That
only-
I will
That's all.
go through the
Ah.
records and I, after passing and after going through your submission, I
Yes,
will
yes.
pass the order. You may.
One thing is
Dr.
saying,
Singh.
Not just one,
Yes,
Lord, sometimes they say, my lord, in hunting a long shot. One shot which was taken by very, my lord, revered friend is
yes,
that this is a case of moral turpitude. Look at the judgment my friend cited. Kindly
Yes.
have a look at that. It's my lord, Sushil Kumar Singhal. The judgment should not have come. The argument, of course, is not made out. Lord, before my lords read it, my lord, the law is a judgment is not to be read like a statute. And the law further is a judgment is an authority for what it decides. And nothing else.
yes.
Now, my lord, may kindly have
Hmm.
para 2. The facts and circumstances giving rise to the present case are that the appellant was appointed as a peon in the respondent bank, Cathal branch on such and such date. The appellant was handed over rupees 5,000 to deposit the same as dues for telephone bills. However, it was not deposited and FIR under section 409. Now kindly see my lord, the para. It is
Yes.
a judgment which would not negate all that is being said. The paras cited are, my lord, 32, which
Yes.
defines moral turpitude. Para 23 is cited. Let's read the para
Yes.
as it is.
Hmm.
Conduct that is contrary to justice, honesty, or morality, in the area of legal ethics, offences involving moral turpitude, such as fraud or breach of trust, also termed moral depravity. Moral turpitude means in the general shameful wickedness, so extreme a departure from ordinary standards of honest, good moral justice or ethics as to be shocking to the moral sense of the community. It has also been defined as an act of baseness, vileness, or depravity. Then see sir, para 24.
Yes.
Same. And then also see in para 24, the second definition. So all this is taking it to the extreme, to the breaking point. This all would negate and would show that this does not fall in that.
Senior counsel Dr. CV requested the Honorable Court that since the Honorable Court has heard finally, then it is in the fitness of the thing that the interim order be passed in favor of the petitioner. In the interim protection be granted in favor of the petitioner. The learned counsel appearing for the original complainant, senior counsel Mr. Nanavati has objected this prayer. However, in the interest of justice, as the matter is heard finally, and all the documentary as well as the plethora of the documents is placed on the court, we considered the same. It is in the fitness of the thing that the matter be decided finally. No interim protection can be granted at this stage. Only after going through the reports and proceedings, the final order can be passed. Hence, the matter is kept for final verdict after reopening of vacation. Matter is heard. Please.
Very deeply obliged. We are very deeply obliged for a very patient
Very
hearing.
Immensely.
Please.
Once again, apologize. I'll handle it, yeah.
Never, never.
I owe you.
Yes, sir.
Deeply obliged.